So yes, today we are going to now take up this and these two maxims. So the first one today would be, he who comes to equity must come with clean hands. Okay, this is something that you guys already know. We had discussed earlier as well, that if you seek a remedy under equity from the court of equity, you must come with clean hands. Okay, another antiquated way of saying that is that he that hath committed iniquity shall not have equity. So if you yourself have committed any iniquity, then you will not have equity. So the question is essentially, the idea is essentially about balancing equity. Okay, so if you have yourself, by virtue of your own action, tilted it against you, then you will not have any remedy under equity. So yes, if you come before the court of equity seeking justice under equity, then definitely you have to come with clean hands. So that's the essence of this doctrine. Okay, so a person who is seeking relief from the court of equity must not himself be guilty of a conduct with regard to the same transaction, and it's between the same parties, okay, which would disentitle him to the assistance of the court. So you shall not do something which is impeachable. Okay, don't, with respect to the same matter and the same transaction. Okay, so why is that the case? Because court of equity, as you know, is a court of conscience. Okay, court of conscience. So because it is a matter of conscience and good faith, so the court will exercise its discretion. As you know, when the matter is with respect to law, it doesn't matter what is your moral character. Okay, it doesn't matter what you have done with respect to the instant matter. If the facts fit into the case of the right being decided in your favor under the law, it will be decided. But that's not the case with the court of equity. So a discretion is exercised by the court under this equity jurisdiction. Hence, court will take this matter into consideration when it decides the matter. So if you come before the court, you must not do something, okay, that will basically disentitle you from the assistance that you were expecting from that of the court. So you have to keep your conscience clear. Okay, you have to come before the court in absolute good faith. Okay, essentially what it says is that if you are seeking any right from your adversary, if you are seeking that certain rights that belong to you be guaranteed be protected as against the defendant, so should you have considered all the equitable rights in favor of the adversary. Okay, so that's the balance of equity that we were talking about. So yes, keep that in mind. Okay, now this is very important in the sense that if the same matter, okay, arises under the law, okay, if your right can be recognized under an existing law, okay, there is no other question that arises. Okay, so it will not look into whether you have been morally perfect in this instant matter. It will not look into all that. Okay, but the same would be looked at, because the question of motive is very important when it comes to exercise of jurisdiction by the court of equity. So as I said, it is discretionary. So because it is discretionary, the court gets to look into your moral character as well, your moral position. Moral character, not generally. Okay, that's the mistake that I had made earlier. So it's not general moral character, whether you are a reputable person in the society, something like that. No, but with respect to the same person in the instant matter. Okay, that's the idea. So if you are morally correct there, then yes, you'll be provided remedy. Now this can be explained with some examples. Okay, that's it. There is nothing more than this in this particular maxim. Okay, now there was this case by the name Everett versus Williams of 1725. Okay, in which basically two highwaymen, okay, basically they entered into a contract. Okay, if it is not considered as a contract. Okay, and they entered into an agreement that okay, they will basically rob someone, and then the gains of that from that robbery will be shared between them in certain proportions. Okay, so when that matter happens, ultimately one party denies the other party his share as agreed upon. they approach the court, but the court says that because the contract itself is a contract to commit a crime, that is not enforceable in the law. But then this is an example under the law, not under equity, because equity matter will not even arise under the law. Such contract will not be recognized. But what I was trying to say is that essentially this is the case. Okay, if the matter is brought before the court is such that it is morally reproachable, then the same will be not acceptable. Okay, but I think there could be better example of this, okay, in its application, in how the maxim is applied in specific cases. Okay, so with respect to application, Dr. Hanbury, a jurist, says that the cases most usually cited as illustrations of this maxim are those in which a suitor has come to the court with a preconceived plan of fraud in his mind. So you approach the court with a preconceived idea of fraud in your mind. So you are not morally right on your part, but you come seek remedy under the court of equity. In those situations, this kind of application of this maxim essentially happens. Okay, so a very important case with respect to this application is the case of Overton versus Bannister. Okay, it's an 1844 case. Okay, in this particular case, a minor, okay, who's not able to enter into a contract, or for that matter, any sort of legal agreement. Okay, so that minor had fraudulently concealed his age. Okay, and he was basically one of the beneficiaries. So by concealing his age, he induced one of the trustees to commit breach of trust. Okay, and by doing so, he made that person deliver some amount to the minor. Okay, now when the minor becomes major, he again seeks to recover the same amount, okay, that he had by fraudulently he had fraudulently induced the trustee to give to him. Okay, so he seeks assistance of the court of equity to recover that amount that was already given to him. Okay, so although you know that minors contracts are not enforceable, okay, but in this particular case it was held that because the minor by his own act had induced the trustee to commit breach of trust, so he will not be given this remedy under the by the court of equity. So minor's inequitable conduct here had put him at this position, and he was denied a remedy under the equity. So this is also a maxim that you guys have probably come across. Okay, there is another way of saying this same thing, that ex turpi causa non oritur actio. Okay, so your action in law will not arise from a immoral cause. Okay, so that's essentially, yes. I'll start with this one. Okay, so which case, Shweta? Overton versus Bannister. Overton versus Bannister. Wait, I'm typing it. In the reading that I have sent you guys, you'll see the description of this particular case. Okay. So this is the case, and then I have another case. So can you please write the names of the cases here? Yes, Nikhil, this is the case. Do you see this? The other case was Everett versus Williams. The previous case is Everett versus Williams. Okay, so yes. So another question. So the maxim you just so this is a maxim you guys have already studied. So ex turpi causa non oritur actio. Okay. Ex turpi causa non oritur actio. Okay. So yes, that's the maxim essentially. Okay, so you have to keep your hands clean. Okay, for you to expect remedy from the court of equity. So keep your hands clean when you seek remedy from the court of equity. So I hope you guys understood the application in this instant case. So the same, because in India we do not have separate law of equity. However, this maxim applies in a sense that this has been incorporated in various provisions of law in India. Okay, so for example, the one that I just explained to you, the facts of the case in Overton versus Bannister can be seen in section 23 of Indian Trust Act. Okay, that talks about uh, liability for breach of trust. Okay, so it goes like this: where the trustee commits a breach of trust. Okay, so where the trustee commits a breach of trust, he is liable to make good the loss which the trust property uh, or the beneficiary has thereby sustained. Okay, unless the beneficiary has by fraud induced the trustee to commit the breach of trust, or the beneficiary being competent to contract, okay, has himself without coercion, undue influence having been brought to bear on him, concurred in the breach, and subsequently acquiesced therein with full knowledge of the facts of the case and of his rights as against the trustee. So you see, this is nothing but in a statutory form, the law which was laid down in Overton versus Bannister. Okay, so the idea essentially here is that if the beneficiary himself had, through his own action, induced the trustee to commit breach of trust, then you cannot, seek remedy under equity, because the you didn't come to the court with clean hands. So that's essentially the idea as discussed in Overton versus Bannister, as you see in the said provision of Indian Trust Act under section 23. So am I clear so far? Am I clear so far? Yes or no, if this explanation was clear? Okay, so let's proceed then. So you have this same thing available in many other provisions of law. So I will just mention generally about them. Okay, so um, if there are certain specific remedies which are available to you under any specific law, it will be available to you as long as requirements of that specific law is fulfilled. Okay, however, under specific relief act, okay, it it gives discretionary power to grant relief. So it's not necessary that the relief that you seek under specific relief act will be provided you no matter what. Okay, judge does exercise discretion in granting you the relief that you seek under the specific relief act. Okay, so for example, if you seek injunction, okay, injunction will not be provided to injunction as a remedy, okay, a relief will not be provided to you if you're seeking that injunction to commit illegality. Okay, so that is the case. Okay, injunction will be provided to you if your, for example, possession of a particular property. Okay, let's take, no, court self-defense becomes a completely different thing altogether, isn't it? That's a matter of criminal law then, isn't it? See, the thing is, try and understand this. Uh, it's the civil matter that we are concerned about here, not criminal matter. Okay, so I'll give you guys an example. So, for example, you are in possession of a property. Okay, you are in possession of property. Someone else has a better title, okay, to that property. Okay, but you are in possession of that property. So what happens here is that uh, you that someone else, okay, who might have better title to the property will not be justified in forcefully removing, you from the property. Okay, that person has to take help from the law. Okay, so you probably understood that even when you have a right, okay, you have to go according to the law. Now let's take another situation. Okay, so suppose you are in the what you are illegally you are improperly in possession of a property. Okay, so someone who has better title can legitimately have possession of the property from you. Okay, but you are seeking injunction from the court that you be not dispossessed from the property. In such case, you are seeking a remedy to continue a illegality. So in those cases, you will not be provided injunction as a remedy. Okay, so that's another example of the same. Okay, the same applies for when it comes to relief seeking rescission or cancellation. So if you are seeking relief of this nature, that is rescission and cancellation, so but if you have acquired some benefit, you have to revert it back. Okay, so it's more or less like what do you call it? Mm, Even though if you come in seek equity, you must also be willing to do equity. So there are kind of overlaps here. Okay, so the distinction is that if there is anything unfair or inequitable on the part of the plaintiff, okay, when you sought this particular relief of rescission or cancellation, then you may be denied that remedy. So this is how this particular maxim applies. However, this maxim is this maxim provides one exception, okay, where even though you might not have come to the court, even though you might not have come to the court with clean hand, okay, but if you subsequently show repentance, okay, so for example, you tried to defraud someone, but you did not, okay, you tried to defraud someone, but you did not continue in that, you gave that up. Okay, so if your conduct shows that you were repentant of what you had done, then in such case, this maxim becomes inapplicable in the sense that the court might consider giving you the remedy. But in such case, you must have stopped short of committing, the fraudulent act. Okay, you might have conceptualized it, but you did not execute that. Okay, in those situations. Uh, Even though you tried to do something that is illegal, but you didn't do it, hence the court of equity might consider your case. Okay, now this particular maxim is different from the other one. Okay, that is the case in which he who seeks equity must also do equity, in the sense that as I told you, in the previous maxim, you are expected to do equity. Okay, so it's not your previous conduct that becomes material, it is the subsequent conduct that matters. Okay, so in that particular maxim, court will give you do equity to you if you are also willing to do equity towards the other party. Okay, so the moral question doesn't yet arise, whereas in the maxim that we just discussed, okay, that is, he who seeks equity must come with clean hands. In this particular case, your past act, okay, so for example, your all the examples that we discussed, okay, your past act will determine whether you are entitled to equitable remedy or not. So that's essentially the distinction between these two. So this is where I had made the mistake, as I told you guys earlier. It is this, that in respect of this maxim, the conduct, okay, that we are concerned about has to be with respect to the instant matter, okay, with respect to the same matter, okay, and it is because it is with the same matter, it's between the same parties as well. So that's the maxim, that he who seeks, he who comes to equity must come with clean hands. So is there any confusion with respect to this maxim so far? Okay, then I'll consider that it's clear. So one more thing that I would like to add here is that what is the utility of this maxim? The utility of this maxim is more or less the same as we have discussed in others. Okay, in the sense that uh, there are specific matters, okay, in which this is applied. Okay, so the matter has become more ossified, okay, in the sense that the requirements that you need to fulfill are very specific, and that is already a matter of law. So not as much discretion is left in the hands of the judges. There is one more exception though, okay, one more exception that I have forgotten. Okay, the other exception is of that of public policy. Okay, so apart from the repentance, the one example that I gave you, there is another exception, that is of public policy. So what is that? So if the matter is such that, okay, if the matter is such that uh, uh, so what's the requirement of this maxim? That if you seek remedy under equity, you must come with clean hand. But the matter already comes under public policy, such that you do not need to come with clean hand, but law has already taken its course. Okay, in such case, this particular maxim does not apply. So it's said that where a transaction is against public policy, the plaintiff need not come with clean hands. So the transaction that had happened was in itself against public policy. Okay, then there is no question of this application of this maxim, because that in itself is invalid. So the question of application of this maxim only comes subsequently. So that's another exception. Anyway, the proper exception is of that of repentance rather than the first one. Anyway, that's that maxim, and after that we have the next maxim called delay defeats equity. Okay, now what does this maxim mean? And this is more or less with the idea of limitation. Okay, limitation law, as you have studied already. Okay, the law of limitation as applies to your legal rights. Okay, so just like that, similar to that, there is this doctrine that applies in case of equity. Okay, now these are not exactly the same thing though, that you guys need to understand and keep in mind. Okay, but the rationale is more or less the same. Okay, there are other names for this maxim. Those are laches and acquiescence. Okay, laches or acquiescence. Now, what does this maxim essentially say? That it essentially says, if you remember that phrase that we used, okay, that vigilantivus non dormentivus juras obveniens, okay, that we studied earlier, that you should not slumber over your rights. Okay, so in equity, the maxim is that equity aids the vigilant and not the indolent. Okay, equity only aids the vigilant and not the indolent. So you cannot sleep over your equitable right. Okay, however, there is a distinction that we need to understand here, that when it comes to law of limitation, okay, if the instant matter comes within the application of law of limitation, okay, then you do not have. So for example, if 3 years time is laid down under the law of limitation to initiate a suit or seek remedy in the court, if you have crossed those 3 years, then you do not have remedy. But for example, before the 3 years, okay, maybe you have come at 2 years 9 months. Okay, that's also a substantial period of time. Okay, so even if it is a substantial delay, it does not take away that right from you. So under law of limitation, as long as you are within the period of limitation, you can have access to the court and have remedy as well. Okay, so that's how law of limitation functions. Whereas in case of equity, uh, there is no such limitation period as such. Okay, so the delay will ultimately be determined by the court of equity itself. Okay, so it could be much less than what the law of limitation lays down. So how does it work in England? Okay, three different ways. Okay, So in those matters in which law of limitation applies, there is no confusion. Okay. However, there are other matters which are of analogous nature. Okay, they do not directly come under the purview of law of limitation, but they are of such nature that you can apply provisions that apply under the law of limitation to the instant matter as well. Okay, so that's the second case. And the third case, which is most essential, is that are those cases in which all those limitations do not matter even before those limitation period is over, because of certain other factors. Okay, because of certain other factors, the court may say that your action, okay, by virtue of your action along with the delay, you have disentitled yourself from the remedy under the court of equity. So these are the three situations. Okay, so some property right which is some property right which is recognized by the court of equity, that such property, if it were under the law, will have certain limitation period. Okay, initiation of a suit will have certain limitation period. Okay, that applies. Okay, there is another transaction which is not directly under the purview of law, hence does not come under the purview of law of limitation, but it's of analogous nature. So for example, something that is contractual nature, something done with respect to that. Okay, if it is analog, it could be analogous with respect to law of trust. Okay, so the provision that applies with respect to contract in relation to limitation might also be extended to that of trust. So that's the second case, analogous matters. The third kind of matter would be those in which it doesn't matter whether the limitation period is over or not. Okay, sorry, limitation period is over or not. In that situation, something more than merely delay would be important. Okay, and what is that? We will look into all that. So yes, the second maxim is delay defeats equity. So it's more or less as we discussed earlier. Okay, so let's look at an explanation of this maxim given by Lord Camden in Smith versus Clay. Okay, he said equity has always refused its aid to stale demands where a party has slept upon his rights and acquiesced for a great length of time. Okay, nothing can call for this court into activity but conscience, good faith, and reasonable diligence. Okay, when these are wanting, the court is passive and does nothing. So essentially, he's talking about application of this maxim in this instant case, and he's saying that apart from the first two that you already know, conscience and good faith, reasonable diligence is also important. So, so the latest part is basically your delay, and the other part, acquiescence, is basically when you know that something is basically being done that will make it difficult for the court to grant you a right, but you don't do anything about it. That's the matter of acquiescence. Okay. But remember this, that there is no universality of application of this maxim. This remains within the subjective discretion of the court. Okay, so it will be decided based on the different circumstances. So that's essentially the case. Okay, but as I told you, it's not merely the delay that leads to application of this maxim. Okay, there are three conditions when delay becomes fatal. Okay, for the person who seeks equitable remedy. And what are those? When the delay results in destruction or loss of evidence. Okay, so not merely delay. Delay is of such a nature that it leads to destruction or loss of evidence. Okay, now in the absence of that, the claim cannot be reverted by the other party. Okay, so you have put the other party in such a situation by your delay that the evidence is gone. So in such situation, you will not be provided the remedy. Okay, the second one is where evidence of an agreement by the plaintiff to abandon or release himself from his rights. Okay, so along with the delay, there is also evidence that you, by virtue of some agreement, you have abandoned that right. Okay, if that is the case, then then basically this maxim applies. And the third one is where plaintiff by his own act induces the defendant to alter his position. So you have done something, okay, which puts the defendant in such a position, defendant to change his own position. So in such situation also, you are not entitled to a remedy under the court of equity. So these are more or less overlapping. As you see, one maxim can be related with another maxim. So far, are you guys clear with the maxim as I'm trying to explain? Is it clear? So understand the distinction here, that in if it were limitation, law of limitation, then all this matters that we just discussed will not be applicable. But in case of equity, because it is also a matter of conscience, so all those other factors will also be relevant. Okay, and if those other factors become relevant, then the law of limitation becomes inapplicable in those specific situations. Okay, and that's the doctrine of laches and acquiescence under the equity. So Strahan had tried to explain this in the following words. He said, the doctrine of laches in court of equity is not an arbitrary or technical doctrine where it would be practically unjust to give remedy, either because the party has by his conduct done that which might be regarded as equivalent to waiver of it. So you, by virtue of your conduct, you have waived it. Okay, or whereby his conduct or neglect he has, though perhaps not waiving that remedy, yet put the other party in a situation in which it would not be reasonable to place him if the remedy were afterwards to be asserted. In either of these cases, lapse of time and delay are most material. Okay, so it's explanation of those conditions that we have discussed. Okay, you put the other party in such a situation that it is no longer that it's something that you should not have done. Okay, and so in such case, of course, because of the delay or lapse of time, you will not be entitled to the remedy that you would have been in the absence of this situation. Okay, however, there are certain exceptions to the application of this maxim, and what are those? Where I mean, those are not really exceptions, as I just said. Okay, if the matter is under the law and the law of limitation clearly applies, then of course there is no question of application of this maxim. But if the matter applies, arises under the equity, then even law of limitation, even before the law of limitation applies, it applies, if those additional conditions that we have just discussed are also in existence, then yes, this maxim will apply. Okay. However, there are certain situations in which, cases in which your delay might be excused. Okay, what are those? So, for example, a situation in which you were not aware of that instant right. Okay, so if you're not aware of that instant right, if you had no knowledge of that right, nor did you have the legal capacity of fighting for that right, okay, in such case this particular maxim does not apply. So what we discussed essentially is how the law works in England. So what about the situation in India? So in India, you then have to look at the law of limitation. So Indian Limitation Act 1963, you can look at two different provisions under this. First, look at Article 113. Okay, there are articles here. Okay, Article 113 of the law of the Indian Limitation Act 1963 that deals with specific performance of a contract, and it says 3 years period is the limitation which is laid down here with respect to specific performance of the contract. And its contract, it says the date fixed for the performance, if no such date is fixed, when the plaintiff has noticed that the performance is refused. So essentially that's what we discussed. Okay, you must have the knowledge, only then the said limitation that we discussed will apply. After that, you guys can also I think Article 113 would suffice for this particular matter. So what it essentially says that the law of limitation in such situation can only arise once you have the knowledge of the matter. So the date fixed for the performance, or if no date, such date is fixed, when the plaintiff has noticed that performance is refused. But if the date is fixed, we will assume that the plaintiff already knows that, knows of the non-performance. So in such case, so this is an explanation of the excuse that we have just discussed. So that's basically what this maxim is essentially all about. So tomorrow we will take up another maxim called equality is equity. Now this maxim, as I told you guys earlier, does not mean putting parties at absolutely equal pedestal, but merely where they should be. Okay, so it's not absolute equality, but some kind of approximate equality as the situations necessitate, will be discussed under this particular maxim. So with that, we end our discussion for today.